A ban on TikTok? Today, the Supreme Court weighed in and decided that the TikTok divestiture requirement does not violate the First Amendment. So the ban will go into effect on Sunday. Let's go ahead and analyze the case. The Supreme Court's opinion just issued at 10 a.m. this morning on Friday, January 17th, that decides, unfortunately, that TikTok ban is not a violation of the First Amendment. As an initial matter, I want to point out that what the court was deciding here was whether the law, which requires the divestiture or sale of TikTok's U.S. entity, does that violate the First Amendment or free speech rights of TikTok or of people who use TikTok for purposes of expression. One of the things that needs to be considered when deciding whether something violates the First Amendment is what level of scrutiny will be applied to it. Here, the court decides to apply intermediate scrutiny, and it decides that the government's interest in protecting against a potential security violation outweighs the potential First Amendment concerns here and is restricted only to the topic of divestiture and does not actually harm those First Amendment rights. Let's walk through the opinion. So this is the opinion from the Supreme Court, and it first describes the nature of TikTok, which many people are familiar with, so I'm going to skip through this. It also discusses that they're going to be focusing on the topic of the First Amendment and whether the national security interests that the United States has in preventing TikTok from being potentially subject to Chinese intelligence gathering is a reasonable justification for requiring divestiture or sale of the TikTok app in the United States. So it has a brief description of what TikTok is, so I'm going to go fast through this particular part. It mentions that there's a concern about national security, and I'm going to scroll all the way down to the analysis. The Act specifically defines two means by which an application can be designated as a potentially banned application or one that requires divestiture, one that is designated as a foreign adversary controlled application. So one of them is by specifically if it's named ByteDance or TikTok. And the second is a general designation for those that are controlled by a foreign adversary in some way, or a threat to national security. So this could apply to other apps. The Act's prohibitions are going to take place 270 days after they are designated on Sunday, January 19th. That will go into effect for TikTok. The Act will require divestiture of apps that are covered by this Act. So the question before the court is whether this violates the First Amendment rights of TikTok. So ByteDance and TikTok, along with TikTok users, filed a petition for review challenging the constitutionality as violating the First Amendment. The D.C. Circuit, which is an intermediate appellate court right below the Supreme Court that decides a lot of issues related to the D.C. area agency actions and things like that, that concluded that the Act does not violate the First Amendment rights. And here, the court granted certiorari. That means that they decided to take a look at this issue as well, and they were trying to decide again whether this violates the First Amendment. The Supreme Court said that it does not. So here's why. First, the court says it's not clear whether the Act directly regulates protected expression. It doesn't say that people cannot put certain content on the internet. It does not say that the app cannot function at all. It simply says that it's required to be divested. And so the court says this divestiture rule does not, in fact, directly regulate protected activity, or it doesn't look like it. However, they decide after considering it and saying, there's probably not a chance that this even qualifies. However, we're going to assume without deciding that the conduct falls within the category of protected speech so that we can conduct a full First Amendment analysis. They decide to do this so that they can show that even if it qualifies for First Amendment protections, those First Amendment protections are overridden by those national security interests here. So there's a couple different thresholds for how we consider First Amendment law, and the Supreme Court is explaining that here. Content-based laws, meaning those that target a specific type of speech based on its content, are only allowed if they're narrowly tailored to serve a compelling state interest. Here, the court ends up deciding that this is a content-neutral law. It's not targeting certain types of content, it's targeting all content from a platform. And so content-neutral laws are subject to something called intermediate scrutiny because they pose less of a risk. Under that test, intermediate scrutiny, something will violate the First Amendment unless it advances important governmental interests unrelated to the suppression of free speech and does not burden substantially more speech than necessary to further those interests. So this is the analysis that the court moves forward with throughout the rest of the opinion. Let's scroll down and look at it. So here, the court decides that the challenged provisions are content neutral and that they need to apply this intermediate scrutiny. And I'll scroll down a little bit more. The court says that the government points out that the challenged provisions are content neutral because they're designed to prevent China from collecting sensitive data of United States citizens and U.S. users, and that is a purpose that the government would try to prevent unrelated to the content of those things that those people are trying to present. So they're saying here that we do not apply strict scrutiny, which is a higher level of scrutiny of activities of the government. We're going to apply a different set of scrutiny here, intermediate scrutiny, because this is content neutral. So let's look at intermediate scrutiny. The court says that because these challenged provisions further an important government interest unrelated to the suppression of free expression and do not burden substantially more speech than necessary to further those interests, this act does not constitute an unconstitutional act in violation of the First Amendment. So the reasons that the court expresses here is that the government has an important and well-grounded interest in preventing China from collecting the personal data of tens of millions of US TikTok users. And then the court also says that even though there are potential arguments that this is not narrowly tailored to that interest, the divestiture requirement is not a narrow tailoring to the potential risk of China collecting that data. The court says, look, the act is sufficiently tailored to address the government interests in preventing a former adversary from collecting that data. The prohibitions and the divestiture requirement are not broader than necessary to achieve this objective, because rather than completely banning TikTok, the act instead imposes a conditional ban only if TikTok is not able to divest out of Chinese control. Now, the petitioners, meaning TikTok and the TikTokers here, made a suggestion of alternative narrowly tailored rules that would help. For example, disclosure requirements telling when the Chinese government is collecting data sharing restrictions, like saying, no, you may not share this information with the Chinese government, or a agreement that helps to protect those national security interests. Petitioners said those would be a lot more narrowly tailored, but the court rejects that. The court says that those alternatives do not alter our tailoring analysis. The court says that they ignore the latitude that we afford the government to design regulatory schemes. We're not trying to decide whether the regulatory path is the best or the most appropriate path. We are simply trying to decide if it is one that is narrowly tailored. And here, because they don't outright ban, but instead impose a requirement for divestiture or sale, this is narrowly tailored, the court concludes. The court also points out that petitioners didn't find any cases in which the court have assessed the appropriate level of First Amendment scrutiny for an act of Congress that was justified based on content-neutral grounds. So saying that if you have an act of Congress that doesn't specify only certain types of speech are prohibited, that it's unusual for the court to say that that violates the First Amendment. And the court points out that even without using access to confidential data that was submitted below, they can determine that the government has reasonable data collection concerns based on the breadth of TikTok's data collection. So ultimately, Congress has determined that divestiture is necessary to address its well-supported national security concerns regarding TikTok's data collection practices and relationship with a foreign adversary. Therefore, the court concludes that the challenged provisions do not violate the petitioner's First Amendment rights. Thanks for listening in. I hope that you learned a lot. The Supreme Court's decision to uphold the act that requires divestiture of TikTok does not mean that TikTok is actually not going to be available. Biden has said that he's not going to enforce it and will leave it to the first day of the Trump administration to figure out what's going to happen next. And Trump, for his part, has also said that he's going to try to work to an alternative solution that won't result in a ban. It's also possible that the app will remain available to users, but will simply not get the result of maintenance or other types of improvements or distribution that would violate the act.